Hello, everyone, and welcome to our latest episode of We Get AI at Work. My name is Eric Felsberg, and as always, I'm joined by my colleague and friend, Joe Lazzarotti. Joe, we have an interesting episode today that, from first pass may seem a little basic, but it's actually really important. And the topic we're going to talk about today is my AI tool actually AI? It may seem simple, but it could have critical implications as you think about your compliance plan as you work with AI in the workplace. Joe, any thoughts to get us started?
Well, first, good to see you, Eric. Hope all is well. I think that there's a lot of, thinking about this question, both from the standpoint of what the technology is or isn't, what the impression of the company's organization believes. Maybe in different pockets, people in IT may think about it differently than people in HR or people in marketing, and then there's, what the law says AI is, because that's, from our standpoint, from our world, that's what matters a lot of times. So, yeah, I think it's something you really have to think about in terms of answering that question, because as you said, it could have pretty significant consequences.
Yeah, and I think a lot of the technology that we use on a daily basis, and we probably don't give all that much thought to, actually, probably is AI, right? But to kind of buttress what you were just saying, the question becomes, but is that the AI we're concerned with? Is that the AI that regulators are seeking to regulate? And when I'm answering questions about AI from clients, a lot of times, at least in the current environment, what clients are interested in knowing, and you touched on this in your comment, is what do I need to worry about from a legal perspective, right? I'm using this tool. Maybe I'm using it as part of an employee or an applicant selection function. And this AI promises to help streamline our process, be more efficient. It will allow us to, vet many more applicants than we otherwise would if we were not using the tool. So, what do I need to worry about from a legal perspective? And kind of the way I think about it is, I think about it from the federal perspective first. And from the federal perspective, one of the things I often think about is under Title VII of the Civil Rights Act, are there issues of disparate impact potentially that I have to worry about? Maybe there'll be an obligation here where I need to have this tool validated. And, as I'm answering or thinking about answering these questions, I think about things like the Uniform Guidelines on Employee Selection Procedures, which still good law today, but it was a document written back in the 70s. But what it talks about in a nutshell is whenever you have any selection mechanism, monitor it for disparate impact. And if you identify that there is statistical evidence of impact, go ahead and you'll need to have that tool validated. And again, when they wrote this law, they were probably thinking about cognitive ability testing or physical testing, the ability to lift a certain weight as part of your consideration for a job. And it's still good law today, right? If we're using an AI tool to make selections, the uniform guidelines would apply. And if you look at kind of how they define what they mean and what they're trying to regulate from a selection perspective, it's really pretty vague, right? It's really any, I'm paraphrasing, but essentially any mechanism used to select employees. And so on the federal level, we kind of have this very broad definition of what potentially could fall under there, but we have to think about that, as we're speaking with employers about using some of these technologies. But Joe, there's a bunch of state laws and local laws, that are coming on the scene, which kind of approach this from a little bit of a different perspective. So I don't, maybe you can comment on that.
Yeah, no, sure. I mean, I think, there's a lot of levels of this analysis, right? A lot of times, I think when we're talking to clients and colleagues, people are focused on, generative AI tools, which is what most people, I think, are using. And now we're hearing a lot about agentic AI, and then there's the more traditional machine learning AI that's been around for a long time. And that's one way to kind of bucket the different types of AI and maybe put some definitions around it. And then, to your point, you start looking at the federal level, and you start saying, well, okay, maybe it's really broad, but then we have to see what other frameworks we're working under. And if you look at how, the EU AI Act, or you look at how, I know, Eric, you do a ton of work with the New York City AI law, and you look at now the California Fair Employment and Housing Act. They define that those set of regulations that were just issued and finalized. They have they have a definition of AI that may not exactly coincide with what is required in New York. And so if you're an organization in multiple states and you're thinking about imposing some type of what we're saying AI, right, some type of tool nationally, you're going to have to really look at those and decide. Well, I think in the Colorado law, for example, it's a tool that assists in making a decision, and I think in the California regs, it facilitates a decision. Are those terms that'll wind up in litigation meaning different things, and they're not defined themselves? So how do you know what that means? And those are just some of the distinctions, right? There's if it's a substantial decision, or if there's how much involvement by the tool compared to the human. All of these things play into, well, do we have to comply with that law? And then there's other provisions in the particular framework. I know another area where California has had some impact on AI regulation is in the area of the California Consumer Privacy Act, and that law, that's only going to apply if the entity is a business, right, under that law. And so, for example, it's a business. You have to do business in the state. You have to control personal information, and then you have to meet, one of three thresholds. One of which is you have to have gross annual revenues above a threshold. I think right now it's 26,625,000. Right, that's what the threshold is right now for the prior year. And so, if you're thinking about it, you might have AI, but you might not. That law might not apply to you. So it's really, I think, an issue of kind of going through and saying, okay, if we're going to deploy this tool, yeah, it might be AI, but it might not be AI under the law that we're worried about in a particular jurisdiction and used for a particular purpose.
Yeah. Yeah, and it's critical. I mean, what you're describing is exactly right, and it's challenging for employers because right now, as we think about using AI tools in the workplace, you are confronted with a patchwork of laws around the country. Now, right now, it's somewhat manageable, right? It's for the most part, even though AI is getting a lot of attention, it's really only a handful of jurisdictions, and right now it's a bit easier to keep track of which laws require what, and maybe is our tool subject to the laws. But to your point, for each tool you have to examine each of the laws, understand exactly what that tool is performing, what type of tasks, how it is doing that, and that may require discussions with your provider, or the developer, to determine exactly how it is that it's going about helping to complete that task. And again, the impact can be significant because you mentioned New York City law. I sit in an office right outside of New York City, so a lot of times we'll be speaking with New York City employers about the New York City AEDT law. And why do we care whether we hit the definition or not? Because if we do, we potentially may have to prepare bias audits. We may have to, in New York City, publish those bias audits on our career site for the world to see, right? We will have to issue certain notices, and what are the content of those notices, and what are the obligations stemming from those notices, right? And then we have to worry about what Colorado requires, and California, and the other states that are kind of releasing their own laws. So this is, while we see some of the same type of themes emerging in a lot of these laws, there are these nuances where it may be considered AI under one law, but maybe not another. And to the point you're making, we don't really have a lot of litigation or precedent, right, to look at, because these laws are so new, and we're all in the same kind of boat here, trying to feel around and do our best to come into compliance and stay there. So this is a significant issue, and as I mentioned at the outset, while it may seem like a really simple question, hey, is this tool really AI? It's a really critical decision point for employers as they think about rolling out some of these technologies.
Yeah, and I think there's two additional points I would make to that. One is, when an organization acts as an employer, you're right, there are those issues in that context. But then it's possible that a business could decide, well, when we have our employer hat on, this law might apply to us because we're making a decision that's a significant decision and making an employment decision. But that same technology applied in a different use case, maybe to decide which tools to sell in a particular market or what have you, may have no implications. The same law just doesn't apply because the way that the law defines a significant decision isn't the kind of activity that's similar to or the legislature in that state decided was a significant decision, like a healthcare decision or a housing decision. Those are other areas that you tend to see in these AI laws. That's one. And the other thing is, what I'm seeing a lot of times is clients that serve business customers and provide services for those customers may have, by contract, agreed to certain limitations on the technologies that they use. In some cases, that's AI. What are you saying in the contract? Is it that you're prohibited from using, or that you have some particular controls in the agreement that you plan to use in the performance of that agreement? And so understanding that, it might be very different than what the New York City law or the California or other state laws define as AI, but it's just what you agreed to by contract. And so that's something I think also, just thinking about the organization as a whole, there's all these different pockets that AI can have some meaning. And so it's really important to understand, when you're using certain technology and how, the applicable circumstances could affect whether there's some, rules governing that use.
Yeah, no, absolutely. And I would just say one last thing around this is that, you kind of have to think about these issues before you go live, right? Oftentimes, there is a lot of excitement, maybe around a particular business unit, whatever it may be, that see the clear advantages that AI can provide. They get excited about the efficiency, and oftentimes there's a rush to just implement these right away because of the impact it may have on the business. But it is really important to kind of have a gatekeeper there, to think about these issues before going live, because it's always easier to deal with some of these issues and understand exactly the road you're going down from a compliance standpoint, or potentially from a liability perspective. What types of risk you're encountering, to do that assessment beforehand before you go live. But Joe, this is as always a great discussion with you. I'm sure we could chat about this for an extended period of time, but we won't for now. But for our listeners, we hope you found this discussion helpful. If you have any questions or you would like us to cover a certain AI-related topic, please do not hesitate to contact us. We have a dedicated email address at ai@jacksonlewis.com. And thanks again for listening.
Thank you for listening to Jackson Lewis's podcast, We Get AI for Work. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient. We Get AI for Work is available on Apple Podcasts and YouTube. For more information on our topics, presenters, and other Jackson Lewis resources, visit jacksonlewis.com.